Good afternoon, folks. My name is Killian Garvey. Thank you so much for joining me today. I'm doing a talk today about writing proofs of evidence. The reason for doing this is I've been asked by a number of people whether I can give some helpful hints, as I see them, for writing proofs of evidence. So I thought that I would post this webinar in order to help anyone who's currently trying to write a proof of evidence. This recording will be posted to YouTube, so there's no need to be writing furiously during it. And I hope to try and make this quite interactive. So there is a chat function. So if you'd like to make any observations or comments or questions, please put them into the chat, and intermittently I'll be going through that and trying to address those questions as much as we can. So I've got various slides. Let me share my screen. Hopefully you can see this. So in terms of who this talk is for, I've done this talk predominantly for someone who's writing a planning proof of evidence for a Section 78 inquiry. However, most of the principles for writing a good planning proof are equally applicable whether you're writing a heritage proof or a landscape proof or highways proof or otherwise. And I'm not writing this with the view of this being for developers or local planning authorities. It should be for both. Ultimately, the principles of writing a good proof of evidence normally read across to both. There'll be a few things that are more developer friendly or more local planning authority, but in the round, I'm writing this for everyone who's considering writing a proof of evidence. And as well, many of the points that I'm dealing with would apply whether you're doing a statement of case or even a planning statement. But I'm gearing this predominantly towards those who are writing proofs of evidence for a planning inquiry. So, an adage I often live by is hear all, trust nothing. And that's certainly the way in which I invite you to take my view on writing proofs of evidence. There's certainly no prescriptive way to write a proof of evidence, and I'd hate anyone watching this to think, oh, this is the way it has to be done. I'm simply outlining principles I think work and some that don't work. But I've seen proofs of evidence be attacked in a number of different ways, and I'll allude to that and talk about some of the different ways in which you can write a proof. There's no one size that fits all, but there's certainly a few principles that rarely work, and I'll be addressing that. So the first thing that anyone should bear in mind when they're coming to write a proof of evidence is thinking to themselves, well, who am I writing this for? And I will be coming back to this point consistently throughout this talk, that your proof of evidence, you don't write it for the case officer, you're not writing it for the public, you're not writing it for the client, you're writing it for one person, the planning inspector. Because it's important to remember that a planning inquiry, there is only one person in the whole inquiry that truly matters, and that's the inspector. Everyone else who is there to help one human make a decision. And you're always gearing everything towards that decision maker. You're there to help them and to try and provide useful information for them. And I will keep coming back to this point, that it's the inspector. Think, what will the inspector be assisted with? I can see that there's already a few people who've got some comments in the chat, so let me jump in. Oh, I can see Tony saying, planning inspectors often dismiss other precedent cases referred to in a proof or appeal statement. Any tips on making sure more weight can be given to these? Tony, don't worry, I'm going to return to that point later on. That is definitely one of the points I wish to address. So stay on for that. Okay, so what I'm going to do is I'm going to talk through the structure of a good proof of evidence, a planning proof of evidence, in a moment. But before I do that, I'm going to give you a very brief anecdote, which might seem like a bit of a tangent, but it's more for comedic effect. But it is highly relevant. So the band from the 1980s, Van Halen, some of you may know, they had a rider, and I was able to get a copy of the rider that they had for concerts. This is from their 1982 World Tour. And you can see, again, you'd be thinking, how on earth did we get to this rider within 7 minutes of this talk starting? But here we go. Bear with me. You can see that in Van Halen's contract, they had M&Ms warning absolutely no brown ones. Now, the story behind why they had this is that they knew that they had a very technical backstage crew and lighting scheme. And if they went into their changing room and that they saw that there were M&Ms with no brown ones, they knew that they were dealing with someone who had read the contract and diligently followed it, such that if they saw no brown M&Ms, they could have some confidence that the things that really did matter had been done properly. And that is oftentimes a good rule of thumb in planning inquiries. You need to give the inspector confidence. You do the small things right, and they'll have confidence that the big things have been done right as well. And to that extent, you need to bear in mind inspectors, and there are countless fantastic inspectors determining appeals, but it is too much for any one individual to be taking on all of the decisions that is required for the purpose of a planning appeal. They do lean on the expert statutory consultees and all the technical witnesses to have done their jobs properly, and they need to be given confidence that you know what you're doing and that you're taking this seriously, such that they can rely on when you say, well, for example, there's no highway issue with this site because the highway authority have looked at the plans and determined that there's no highway safety issue, assuming there's no reason for refusal, it's not a main issue, that the inspector can have confidence that that point has been dealt with appropriately and they need not unravel it, and they can focus on the key issues in whatever that appeal might be. So a lot of these points I'm going to make, they might seem simple and they might even seem benign, but they're important to get right, because if you get these small things right, you're giving the inspector confidence that the really important things have equally been done correctly. So the structure of a good proof of evidence. Here are always, I think, a good proof of evidence can be structured. So you need to have your front page, which needs to identify a whole host of different points: who you are, your discipline, what the site is, the appeal reference number, sometimes the local planning authority reference number as well, a description of the development, who the appellant is, and who you're acting for, whether that's for the Rule 6 party, the appellant, or the local planning authority. All these things you want to have jumping out from the front of the page. Now, I can tell you that where an inspector picks up a proof of evidence and they're unclear what it's about, as in they don't know who it's for, they don't know whether it's for the local planning authority or the appellant, and they don't know what discipline, whether it's flood risk or heritage or planning or otherwise. If they don't know those things, they're immediately approaching a document in a negative way. So you want to make sure you get these simple wins correctly, so that they can have confidence that you know what you're doing. The next part of your proof, I'm deliberately skipping over executive summary, which I'm going to come back to later, because some people might think I'm going to start with an executive summary, and I will come back to that point. But assuming you don't have one, or if you do, as I said, we'll come back to that, you want to set out your personal background. So you set out your name, your qualifications and experience, a declaration, which I'll come back to, what professional bodies you're a member of, and you also want to mention when you were first involved with the site and the extent of your involvement. So, and that point is quite important. You want to set out, when you visited the site and whatnot, because you don't want those points coming out during the appeal. It's best to have those points front-loaded. So, for example, if you were involved in the application and your fingerprints are all over the application documents, you want to acknowledge that. But equally, if you came in at the appeal stage, which is absolutely fine, it's no indictment on your ability to be an expert witness, you want to say so. Let's give an example. If you're the landscape witness and you were the person who was responsible for the landscape and visual impact assessment, you want to acknowledge that point and say, I did that and this proof of evidence builds upon that work. Equally, if you're a new landscape witness and you're coming to it fresh, you didn't do the LVIA, you want to say that and say, and I deal with areas where I might disagree with those documents or otherwise, or agree with them. I have had it before where witnesses have said, when have you first visited the site? They've been asked that question and they said, I've never visited the site. You want to address those points early on, and hopefully you have visited the site. As regards a declaration, there is no standardized wording for that, but the following paragraph tends to be one I see quite a bit, and I think it's probably inappropriate. The evidence I have prepared and provided for this appeal is true, and has been prepared and is given in accordance with the guidance of my professional institution, irrespective by whom I am instructed. I can confirm the opinions expressed on my true and professional opinions. Okay, so we've got to the front page and the who you are. We then want to get to the introduction. Now, as regards the introduction, you want to provide very brief details as regards what the site is and the appeal is. And I'm going to emphasize very brief details because you need to remember you will have a statement of case and, critically, a statement of common ground. What you don't want to be doing in your proof of evidence is repeating and reciting evidence and material that will be found in other documents. It is a big problem inspectors loathe, and I'll come back to that. There's actually explicit guidance from the planning inspector on these points. Now, I know that a lot of planners in particular, they feel nervous when they don't include these sort of benign background information, but I guarantee you the document will be much more succinct and persuasive if you cut out all the background dross that we found in other documents and get to what your actual case is, rather than just setting out lots and lots of background. And this is where I'm very keen that this talk is not a rant from me about all the grievances I have towards planning proofs. And I do jump in the chat if it feels like that at times. But I see this an awful lot, and I know inspectors loathe it as well, where a proof of evidence, you might get 50 pages into the proof and you've actually read nothing of consequence. It's all planning history, policies in an abstract sense, appeal site description, appeal proposals, the history of the application, none of which is going to persuade an inspector one way or another, and all of which will be set out in other documents. You don't need any of that. Cut to what your case is. I guarantee your proof will always be better. And I come back to the point of who are you writing the proof for? You're writing for the inspector. They don't need a lot of that background information, which they'll find elsewhere. They need you to set out what your key arguments are. And the consequence might be that your proof might be quite short. That's not a problem. There's a joke amongst lawyers of saying, I'm sorry that the document's so long, I didn't have time to make it shorter. That's certainly true of planning proofs as well. The shorter, succinct, and throughout planning proofs of evidence are oftentimes much more effective than the long proofs that recite everything and provide all the background information. Typically now, for a modern planning inquiry, you will have had a case management conference with the inspector prior to you producing your proof of evidence. And following that case management conference, the inspector will identify what they regard to be the main issues. It's often helpful to refer back to those main issues and tell the inspector which issues you're addressing and which issues are dealt with by other witnesses. And indeed, you want to set out the other proofs you rely upon. So, for example, if the case involves heritage, landscape, and planning, for argument's sake, you would want to say, I defer to Mr. or Mrs. X on the landscape evidence and similarly on the heritage evidence. And simply just cite, I rely on their evidence on those points and I don't deal with them. You also want to mention any updated reports, whether that's a BNG update, a biodiversity net gain, or if you've got any updated information, you probably want to be mentioning that in this introduction. And you also want to address any procedural issues. And again, this is very much there isn't one size fits all, but for example, if you've been made changes to the application plans, you might want to address that. Or if the reasons for refusal have been dropped or modified, you might want to address that. But always remembering, you've got a statement of common ground. You don't just wish to be repeating information. That's all the sort of benign, boring argument points. That can all go in the statement of common ground. All the points that are commonplace. The reasons for refusal say this, but reason for refusal 3, addressing the absence of a Section 106 agreement, has been resolved. Those sorts of points you don't need to deal with in your proof. Put it in the statement of common ground. Okay, I'm going to pause there because I can see some hands raised. So Mohammed says there's no need to repeat elements from the OSS report, statements of case. The proof of evidence can be succinct. Absolutely right, Mohammed. And don't just take my word for that. I'm going to give you a little extract right now from the planning inspectors. Hold on, bear with me. This is a note that the planning inspectorate have put together as to what should be in a proof of evidence. And this applies to all proofs of evidence. It deals with what should be in there, and we'll come back to some of these points. But what a proof of evidence should not duplicate information already included in other inquiry material, such as site description, planning history, and the relevant planning policy, and recite the text of policies referred to elsewhere. It need only identify the relevant policy numbers with extracts being provided as core documents. So that's explicitly from the planning inspector telling them, we don't need you to repeat information that's been set out elsewhere. And I guarantee that I'm always confronted with a nervousness amongst some planners when they think, oh, well, are you sure I shouldn't be putting it in? But I guarantee that's what the planning inspector are telling you to do. And the document will always be stronger where you're not reciting lots of boring background that's set out elsewhere. You just cut to the chase. Thanks for the question. Sarah King, that quote about having time to make statements short ago, it's a common joke amongst lawyers. And I guarantee it very much applies. I remember the exercise that I was asked to do in law school that you had to describe something quite complicated, but you were given only 500 words. And the exercise of doing that forced you to realise how much excess language you use. Because when you really cut down to what do I actually need and what don't I need, you find you just actually become much more succinct as a user of the English language. But it's definitely the case of trying to keep things short and snappy that is the harder task. Andrew, colleague has mentioned inspector imposing a 3,000 word limit. Understandable for conciseness, but any views on where you might be giving planning and technical responses as a single witness? Well, just on that, I'll return, Andrew, thanks for the question. I'll return to what the PIN's guidance says on that. Now, it says the format of proofs and appendices. It says proofs to be no longer than 3,000 words, if possible. Where proofs are longer than 1,500 words, summaries are to be submitted. Now, in reality, I would suggest that almost all proofs of evidence I see are more than 3,000 words, whether it's right or wrong. Now, a big theme of this talk will be there's so much redundant information being put in proofs. And oftentimes what you really need isn't in there, and what you don't need often isn't there. So there's always opportunities to make the proofs more succinct. But oftentimes I don't personally adhere to the 3,000 word rule as a hard and fast limit, and nor do I ever see inspectors treating it as that. Inspectors are pragmatic. Ultimately, the proof is as long as it needs to be. I have seen proofs of evidence that are hugely effective and they're 10 pages long, and they're below the limit. Equally, some proofs of evidence, it's unavoidable. There's so much technical information that needs to be dealt with. I've seen proofs that go to 100 pages. And now that is an exception, but sometimes when you get into the detail, you realise it has to be very long. And you're governed by the material. But hopefully a lot of what I'm gearing you towards is this notion that actually a lot of the information that's in there, it doesn't need to be in there. The proofs oftentimes can be much shorter and more succinct and more effective as a consequence. Thanks for the question. Michael asked for the reference to the PIN's document, please. It's an annex from the PIN's procedural guidance. Okay, well, I can see there's a number of questions, and indeed a quotation from Mark Twain, which is very useful. Thank you, Sue. I'm going to jump back to some of my slides, but I'll keep going with the questions as we go. Thanks so much for the contributions, folks. Okay, so back to the slides. So we dealt with introduction. The next point, planning history. Now, the default position is you don't need to cite this in your proof of evidence. And indeed, we see that from the PIN's annex. You oftentimes don't need the planning history. It's oftentimes just boring, benign information. It can go in statement of common ground or statement of case. More often than not, there's never going to be disagreement on what the planning history is. So there's no reason it can't go in the statement of common ground because it's matters of fact. So it should be capable of agreement. There might be occasions where you do have to get into the planning history. And the most notable is where you will have had a recent appeal decision pertaining to the site, whether it's been quashed or whether this is a redetermination. You've had a previous appeal dismissed, for example, and someone's coming back in for another go. Oftentimes you might wish to deal with the planning history in that sense of just dealing with that previous appeal decision, setting out, this is what was said previously, this is what we disagree with, or this is what we do agree with, or this is what has changed since then. But that's the exception rather than the rule. The normal rule is planning history you don't need to get into. And again, don't take my word for it. It's from the PIN's own procedural guidance. Next, planning policy. Now, here's where I'm really at risk of ranting, because I see most proofs of evidence include a very long, boring section dealing with planning policy in an abstract sense, where you'll have parts of the proof saying the National Planning Policy Framework is a material consideration. It was adopted on X date in December 2023. There is a golden thread, the presumption favours sustainable development, and just sets out really boring, benign principles. And again, coming back to who your audience is, the inspector knows all this. They don't need you setting out basic parts of National Planning Policy Framework, because in reality, the inspector knows this, and if they don't, you've got bigger problems. So you don't need to be setting out all these boring, abstract notions of planning policy. And again, don't take my word for it. In planning inspector, they only say 2 things that you shouldn't be doing. And this is one of them, which rather speaks to the point that inspectors hate it when you've got long, boring sections of policies just being set out. And I see this an awful lot where you just say, policy SH1 of the development plan includes a settlement hierarchy. It directs development towards these, and it just sets out what the policy it says without actually applying it or giving any application to the appeal site. So oftentimes, this section on planning policy, it's oftentimes not required. And if you are going to deal with a planning policy section, don't just set out what the policy says. Keep applying it to the site. Never deal with it in the abstract. I mean, the policies in the NPPF, you never cite in the abstract because the inspector knows what the NPPF says. You never need to just set out what those policies are. But if you're going to set out policy in the development plan or the NPPF, keep bringing it back to how that is relevant to this site. Don't just cite what the policy is. Focus on the policies that are relevant. So oftentimes that's the policies and the reasons for refusal. There might be occasions where there are competing policies, which, let's assume you're for the developer, you'll set out the policies that are against you, which should be, if everyone's done the job properly, should be the policies and the reasons for refusal. But there might be some countervailing policies and development plan that you rely upon that support your scheme. You want to deal with them. What you don't want to do is just have a section of 20 policies setting them all out, because I guarantee rarely is it the case that there's that many policies that are particularly of relevance. Normally you'll have a few key policies, and that's kind of what you want to do. Focus in on those key policies, tell the inspector how it's relevant, and just cut through a lot of this background information, particularly when it's been set out in either the office report or the statement of case or the planning statement. And also, decide who in the team is dealing with the policy. And I'll come back to this point later, but that's a hugely important point. You don't want to have the landscape witness dealing with the landscape policy and the planner dealing with the policy, because oftentimes you'll get contradictions. So normally have one person dealing with the policy, and more often than not, it's best for the planner to be the one to do that, but it can be team specific. Sometimes there might be a particular reason why it's appropriate for the landscape witness to deal with the landscape policy. But as a rule of thumb, it's normally for the planner and other technical witnesses to just deal with the impacts. I'll come back to that point later. So let me just jump back to questions. James asked a question. As a highway witness, I've noticed the vast majority of inspectors have limited detailed knowledge experience of traffic modelling models and how they work. Sometimes that's a crucial issue. Often impossible to limit a highways proof to 3,000 words. Any tips on how to simplify quite complicated explanations on modelling and the outputs? Well, James, as I indicated, proof is as long as it needs to be, and needs to be. That's not an endorsement of saying don't worry about the length, because I'm hoping that the theme is coming across, that keeping them short and simple is a good rule of thumb. But even adhering to that rule, sometimes there's just no way of abbreviating it. So sometimes if the proof is longer, so be it. The inspector won't begrudge you, provided you've kept it as in key important points and kept it succinct. But sometimes appendices can be really helpful. So if you are dealing with lots of technical modelling, you can say the outcome of the modelling is X. That can be the headline in your proof. The methodology as to how we've arrived at that is in Appendix A. And that means, you're keeping the key point in the proof. And if the inspector wants to sort of interrogate the background of how you've got to that, it might be in your appendices, how you dealt with those sort of points. Ian Williams, many will be relevant to potential conditions. You don't use the proof of evidence to deal with conditions, Ian. if you've got policies that are relevant to the conditions, then you can deal with that in the conditions session. But I guarantee the inspector doesn't need a long recital of policies relevant to conditions. I mean, unless you're in that rare example where the conditions are the primary dispute between the parties, but almost never is that the case. And then Mohammed's asked from the appellant side, isn't there a case of ensuring all aspects are covered so that the best case has been made on their behalf, and of course the fee is justified? Fee is justified. I set out at the beginning, Mohammed, the proof is not written for the client, and you need to manage your client's expectation if they are thinking that you're like a short proof means that you haven't done the work. The long proofs, they are the easier ones to write because you just do copy and paste from officer reports, statements of case, and otherwise. It's the shorter proofs. They are the harder ones to write. And if you were thinking, I need to put this in to justify my fees to the client, that's a conversation to be had with the client because you're not writing the proof for them. You're writing it for the inspector. Ultimately, your client's going to be greatly appreciative if you get them over the line, which means persuading the inspector, not that you've done laborious, boring proofs of evidence. And you'd be surprised how many clients say to me, I stopped reading after page 20 because it just seemed so long and boring. Can you read it, barrister? Because I couldn't make sense of that planning proof of evidence. So don't think that your clients are impressed by long documents. Rarely are they. And Jonathan, is it suitable to use plans, diagrams to explain things rather than lengthy text? Absolutely it is. And indeed that will be encouraged. So absolutely there is. Okay, going back to my slides, folks. Then I've said, get stuck into your case. And get stuck into your case as soon as possible. All those preceding sections that I've just dealt with, they should be really short. You want the inspector to be getting a sense of what your case is as soon as possible. How you go about addressing your case, there's no one size fits all, and oftentimes it can depend on what the issues are. Sometimes you'll structure it around the reasons for refusal and provide, an answer to each of the reasons for refusal if you're depending which side you're on. Sometimes you might just set out what the case is for the appellant or the case for the local planning authority. I've equally seen it set out where you'll set out a series of propositions. Or, this is one I particularly like, you'll set out what the main issues were identified by the inspector in their case management conference notes, and you'll address, well, I'm addressing main issues 1 and 4 in this proof of evidence. Here's my points on issue 1, here's my points on issue 4, under various subheadings. That's my preference, generally, but it's not, it's case specific. Sometimes there's reasons to just go with the reasons for refusal. But again, with my adage, you're always writing this for the inspector. The inspector's told you what their main issues are, so you're trying to gear your proof towards them. What are the points that they say they need help on? So you're gearing it towards that. And a good tip is before writing, you want to write out 3 bullet points for each subheading. What are the key points that you're trying to make? You then, you want to set out, and this is for developers, not for local planning authorities. Local planning authorities, you're sort of largely constrained by your reasons for refusal. If you stray outside the reasons for refusal, there's always a risk of costs. And, if you're going to go outside them, you'll hopefully discuss that with your barrister. So normally you're just going to your reasons for refusal and your proof of evidence should be therefore restricted to that reason for refusal. If you're for the developer, you do have to acknowledge that there's third parties who will have made various comments, and you do want to cover those points off. Now, assuming that they are not main issues identified by the inspector, and common ones might include highways and drainage. Not always, obviously, there's plenty of cases where they are main issues, but it's not uncommon that those points will arise even if there's no reason for refusal from members of the public. And you want to address them, albeit briefly, in its own discrete section. You'll often see when you read appeal decisions, you'll have the inspector saying main issues, and they'll address that, and then they'll have a section of the appeal decision saying other matters. You're helping the inspector write that other matters section. Those issues that aren't main issues, but the inspector needs to say something about it because someone from a member of the public has said something about it. And that's oftentimes just referring the inspector to where in the documents they're looking for. So if there's a highways point made by a third party, you might say, well, the highway authority provided their consultation comments on X date. It's in the core documents. They had no objection subject to conditions. The application has been supported by technical transport assessment, which you'll find at the core documents at X, which concluded that there wasn't a severe impact. and that the access was acceptable. The officer report similarly didn't raise any concerns with this. Nice, brief, succinct, but just referring the inspector to where in the documents they need to look for those answers. And same on drainage. But you want to have that as a discrete section, but that's if you're for the developer. I'm going to stop there, folks, and just see if we've got any more questions. Victoria. Hi, Victoria. I've never seen a list of main issues from the inspector in advance of proof submission date. Is it usually received at an early stage? That's probably in an enforcement context. You won't normally have those main issues, but in a common Section 78 planning appeal, where it's an inquiry, more often than not now, you will have had a case management conference and you will have had those main issues identified. Where you've got that, it's a gift, because it's the inspector saying, these are the main issues I want you to focus on, and you want to adhere to that. If you haven't got that, then you would want to be focusing on what, let's assume it's an enforcement context, what are the issues that have been raised in the enforcement notice, for example. Nick, do you identify and address policy changes or planning guidance changes that occur between decision and appeal in the same concise way that may give rise to potentially new material considerations as to acceptability of the application? Absolutely. Absolutely, you should. So if whatever the current policies are that you're dealing with, you want to deal with that. Now, again, statement of common ground is really helpful. Those sorts of points ought to be matters of fact that can be dealt with in the statement of common ground. Because again, your planning proof of evidence is to deal with is persuading the inspector of your case, not setting out background. And much of that benign background you can put in other documents. But if it hasn't been put in the statement of common ground, because for whatever reason it hadn't been dealt with, then you probably do need to deal with those points. Since the application appeal was lodged, the local planning authority have adopted X plan, therefore the policies now are X and Y. But again, that sort of benign material can often be, as I said, put in the statement of common ground. Okay, I'm going to crack on with the slides, folks. And then you want to come to your planning balance, again, in the context of a planning proof of evidence. So you would want to set out what weight scale you're applying to. Now, there isn't, and people have asked in advance, is there a preferred weight scale from the planning inspectorate? There isn't. The chief, the head of the planning inspector has indicated that PINs are looking into this as to whether they have standardised language. I like the language of limited, moderate and significant, but acknowledging that the MPPF prescribes certain weights that you need to use. So it uses great weight for heritage and substantial for greenbelt. So you need to adopt that language. But whatever weight scale you're using, it's useful just to set out, these are the adjectives that you use to describe different types of weight. You then want to set out what the harms and benefits are and be even-handed in that respect, whether you're for the local planning authority or the appellant. You want to set them out in exactly the same fashion. It looks terrible when you've emphasised one and ignored the other. If the local planning authority say, I accept there will be some benefits of housing, but notwithstanding that, here's all the harms. It looks like you've been very trivial, and it doesn't look like you've been in any way even-handed in dealing with what those benefits are. Set them out. Guarantee, if you don't set them out, you'll have someone like me criticising you at an inquiry. And similarly, if you're the appellant, acknowledge those harms. Don't try and trivialise them. Ultimately, the inspector, it smacks of lacking credibility if you don't have that even-handed approach. You want to oftentimes set out the alternative scenarios. So, for example, if you're for the developer, you might say, our primary case is we conform with the development plan because of X, Y, Z. If, however, that's not accepted, our secondary case is that the development plan is out of date for X, Y, Z. Sometimes you might just have one primary case. Sometimes you might have 3 or 4 different. But you want to set out each of those. This is the primary case. This is the secondary case. This is the tertiary case. I think it often works well in your planning balance section that you did give a brief description of each harm and benefit. So, for example, let's say we're dealing with a housing appeal. You might say the benefit of market housing. Well, in light of the fact that the council have X amount of housing need, I accept that significant weight should be given for market housing. And that's the sort of thing you could put in whether you're for developer or local planning authority. Similarly, affordable housing, economic benefits, and equally, the harmful impacts on the other side of the fence. You want to have a short little subheading for each harm, each benefit, and a short little description as to why, what weight you've afforded it, and briefly for what reason. And then normally you want to bring that all together into a summary table setting out each of the whether it's benefit or harm and what weight you've ascribed to it. So that, I think, is a general good structure. I'm now going to move on to what I think are some of the sort of main mistakes that I see with proofs of evidence. And apologies if this seems ranty or whatnot, but these are common mistakes I see. So it's hopefully good tips and tricks to learn. But just before I do that, I'm going to go back to questions. So Jonathan said, where the statement of common ground is not yet agreed, is it reasonable to refer to the first draft without prejudice version X to avoid repetition? I'm afraid, Jonathan, it's not. If you're producing a proof of evidence and there is no statement of common ground, sometimes you've got to include benign information in your proof. I know that in an ideal world, this is why you get statements of common ground agreed before proofs of evidence. Indeed, that's the way the planning inspectorate wanted to be, so that the proofs can focus on the main issues and not repeat all of that information. Sometimes there's delays or timetables don't work, and sometimes you fall into that trap where you've got to put the information into the statement of common ground. But the early versions of the statement of common ground, you can't rely on them. Until it's agreed, it's nothing, essentially. And Mohammed, is it good practice? Yes, as I indicated, Mohammed, that's the way the planning inspectorate wanted to work. Sometimes it doesn't work that way, but that's the way it should work. And then Ben asks, is it acceptable to, quote, highlight any points of dispute, disagreement in an appellant's appeal statement from a local planning authority's perspective, such as interpretation of policy? If I've understood the question correctly, Ben, if you're dealing with policy, for example, let's say you're for a local planning authority and you have read in the appellant's statement of case that they are saying policy X means something. It's absolutely, not only is it appropriate, it's the right thing to do to set out, I understand from the appellant's statement of case, they interpret policy X as meaning this, and therefore that aids them. I disagree with that interpretation for these reasons. That's absolutely the sort of information the inspector wants to see in your proof of evidence. It's not an abstract discussion of the policy. It's really dealing with what the detail is and what the actual point the inspector's there to determine. And Emma asks, if you're a Rule 6 party, are they party to the statement of common ground? Would your proof differ in this case? There's no rule of thumb. I've dealt with numerous cases where there's Rule 6 parties. Sometimes they are parties to the statement of common ground, sometimes they're not. My own preference is that they're not. You get a statement of common ground between the appellant and local planning authority for the simple reason that the less people have to sign it, the quicker it is to get it agreed. And as hopefully this talk's demonstrating, that statement of common ground is really important to get that agreed early. But you might have a separate statement of common ground with the Rule 6 party. And yes, your proof would differ if the Rule 6 party are bringing additional points to the fore. So it might be, here are the issues between the local planning authority and appellant, but here are the points the Rule 6 party also raise. And if they're main issues, then you deal with them as such. Just before I jump back to my slides, Lawrence asked what's my view on rebuttals. What's a good approach? So rule of thumb, inspectors don't like rebuttals. So the rule of thumb is don't do one. But where rebuttals sometimes are required, when they sincerely are rebutting something from the other side's proof of evidence, they should be short, they should be referring to what it is in the other side's proof of evidence you're responding to, and they should only really be done to save inquiry time. So let's say you hadn't anticipated a point that the other side are taking. Rebuttals can be useful to say, in light of them raising this point, here's the response to that. But as a default, don't do it. And that's the way the inspectorate normally ask you to operate. And oftentimes it's technical issues. So, for example, 5-year housing land supply, it might be you read the other side's proof of evidence and you realise, this is the few issues we're arguing about. So here's some rebuttal evidence on those sorts of points. Mohammed said, the inspector asked if the Rule 6 party involved in the statement of common ground. As I indicated, there's no rule of thumb. Different inspectors take different approaches. I can only tell you my favourite approach is to have one statement of common ground with the council and appellant, and a separate one, if needs be, with the Rule 6 party. And I only do that for the pragmatic point that it just expedites getting the documents agreed. Okay, back to the slides, folks. I will come back to questions. Thanks so much for the input. So here are some of the main mistakes I see with proofs of evidence. A huge one, and this happens all the time, not dovetailing properly with the other proofs that are before the inspector. So if, for example, you've got heritage, landscape, and planning, they're the main issues and they're the main witnesses you've got. What you don't want to be doing in your planning proof of evidence is repeating any of the contents of the landscape or heritage proof, because at best, you'll just be repeating it, as we've indicated. You don't want to have repetition. You want to keep things concise. But at worst, you contradict what they say. So you'll take their conclusion, their headline points. So, for example, the heritage proof has identified less than substantial harm at the lower end of the spectrum to this designated heritage asset. I factor that into my planning balance. You'll take that headline point, but you won't detail why the heritage proof has dealt with that point. You don't need to. The inspector will read the heritage proof of evidence. But it's really important you each understand what you're each dealing with and how those proofs interrelate. And that's one of the biggest issues I see a mistake happening, where it's sort of you're passing the baton. If you imagine that you're all running, a circuit and you each have your role to do. At what point are you passing the baton on to the next runner to take it to the next leg of the race? That's what you've got to make sure you're absolutely clear on. Who's dealing with the policy? Who's dealing with the balance? Who's dealing with the benefits? A good rule of thumb, you have your technical witnesses, so in this instance, landscape and heritage. All they do is identify what the harm is and potentially what the benefit is. They don't try and quantify whether they never should say something to the effect of, I invite the inspector to grant permission, or I invite the inspector to refuse permission. It's not your job. Stay in your lane. Your job is just to identify what the harm is or the benefit. And then you leave it to your planner to take all that up and put that into a planning balance, which concludes whether permission is granted or refused. Equally with policy, there isn't a one-size-fits-all, but my general rule of thumb is I prefer the planning witness to deal with the planning policy and the technical witnesses, landscape and heritage, not to deal with the policy. They just deal with what is the harm, what's the benefit. Also, a balancing act. I'll give an example from last year. I was the local planning authority, and the appellant, their heritage witness had identified heritage harm and heritage benefits and had balanced one against the other to come out to an overall conclusion. So if you imagine, they had said the harm was, for argument's sake, 7 out of 10. They'd said the benefits were 2 out of 10, and they'd balanced one against the other to say, overall, therefore, it's 5 out of 10. I'm using this in this sort of simplified way to explain the analogy, but they've balanced harm and benefit to arrive at an ultimate conclusion. The planning witness for the appellant then said, well, I'm taking this 5 out of 10 harm, and I'm going to give that weight, but equally, here's all the heritage benefits that I'm going to give significant weight. And they just hadn't aligned themselves, because one witness had sort of balanced harm and benefit to come out with a view, and the other witness had disaggregated them and tried to give the benefits, and sort of brought the benefits back in again, give them another bite of the cherry. And they sort of fell apart in cross-examination because they hadn't realised what the heritage witness had done. So you just need to make sure that you're aligning yourselves. Next mistake, copy and paste. Huge issue with a copy and paste. And this again comes back to the point of don't be repeating benign background information. All of that can oftentimes go into the statement of common ground, or it's in the planning statement, or it's in the statement of case. You don't need to set it out again. Oftentimes, as a good rule of thumb, if you're copying from another document, you're normally doing it incorrectly. Rarely, if ever, should you be using copy and paste for the purpose of writing a proof of evidence. Another main mistake is the over-reliance on other appeal decisions and or nearby sites. Now, a question I was asked at the beginning of this talk is, how do you get inspectors to take more attention of other appeal decisions? The answer is you don't. Inspectors typically hate it when you're trying to say, this appeal was granted up the road, why can't we get permission? Or the local planning authority granted this site across the road, why aren't I getting permission? It is the best example of the brown M&Ms, as I'm saying. This is the common mistake that people make. It is probably the most common argument I see in planning proofs of evidence. Also happens to be the least persuasive, which is, look at what they got away with, why can't we? It almost never persuades inspectors. And more often than not, it screams of someone who's amateur, because inspectors grant appeals on their merits, not on some sort of comparative exercise with another appeal site. Now, that's not to suggest other appeal decisions are irrelevant. There can be key principles you gain from other appeal decisions, for example, on sort of principal points. So, for example, in this appeal decision, the council found that their development plan policies are out of date. Now, that oftentimes can read across to other appeals. But trying to draw a comparison between different sites, that is the easiest way to aggravate an inspector. I guarantee if you're going down that route, you normally want to realise that that's not going to persuade, and it's unhelpful to inspectors. And how often have people read an appeal decisions? A number of appeal decisions are brought to my attention, but I don't have the full details in front of me, and in any event, I determine this appeal on its own merits. That the subtext of that is, stop showing me redundant appeal decisions. I'm determining this appeal, not reviewing those other decisions. I can see some other people jumping in. So Michael asks about consistency in decision-making. Well, if you're in an appeal context, the inspector doesn't have to be consistent with the local planning authority because they're a different decision-maker. In terms of inspectors being consistent with each other, that can be a relevant point. And I'm not suggesting other appeal decisions are always redundant. For example, if you've had an appeal decision come out, which, as I said, makes a point that this development plan policy is out of date, well, that not only is that useful, that's something you probably should be drawing to the inspector's attention come what may, whatever side you're on, because the inspectors need to be consistent on those sorts of questions. So there are sort of principles you can take from another appeal decision, but that's without mentioning the merits of that particular site. It's more a discrete commentary on a particular policy, or a discrete commentary on where the development plan is, or what weight they are affording the emerging plan. So you can refer to appeal decisions, but more often than not, I see people trying to bring out, well, look, this site over the road, the landscape impact didn't seem significant, and they granted permission. Why shouldn't we get permission? You're never going to get permission on that basis. Ultimately, it's a different site. It will always give rise to some difference. So you rarely, if ever, do you want to go down that route. And Harry, what about using decisions of inspectors agreed with your views on the character of the area? The default point is rarely does trying to draw comparisons between different sites. Normally that antagonises inspectors. Now, if you've got the inspector on the adjacent site saying, I accept that this site is part of a larger valued landscape, which extends across this area. Now that you would read across and say, well, look, this as an inspector identified a valued landscape. More often than not, that's not the way inspectors' decisions are written. And just as a rule of thumb, I'm not saying you can never refer to other appeal decisions, but it is oftentimes overdone, and it is oftentimes an easy way to aggravate inspectors. More often than not, it's not useful to you to try and draw a comparison between the merits of different sites. And then what about interpretation severity in respect of highways harm? Again, I would be reluctant about going down that route. If you've got a discrete point, let's say the inspector has said, well, I find that being contrary to Manual for Streets guidance X is a strong indicator of being severe impact. That sort of discrete little point you can draw out as a discrete little quotation from the inspector's point that you might have in your back pocket. But again, at the risk of repeating myself, I'd be wary about trying to draw lots of those comparisons. And Michael, factual points convention, not subjective statements. Yeah, that's not a bad point. And then Steve asks about footnotes should be used. Nothing wrong with footnotes if you're referencing other reports and whatnot. Again, just make sure that the document is easy to navigate. The next point, whinging about mistreatment. Again, this is another common mistake that people make, that if you have someone who's very aggrieved, this is more often for developers, I have to say, but if they are aggrieved in the way in which the appeal was conducted, or the application was conducted, and they use the proof as an opportunity to sort of whinge about the conduct of the local planning authority, it's normally screams of an amateur proof of evidence. It's normally irrelevant to the merits of the appeal. It's normally wasted breath. And ultimately, the only reason you'd ever really complain about the way in which the council have dealt with matters, more often than not, is if this is on the basis of pursuing a cost application. And if you're going to pursue a cost application, put all that information in the cost application. Don't put in your proof of evidence. The objective of the proof is to persuade the inspector of the merits or problems with the side, depending which side of the fence you're writing it from. It's not an opportunity to try and just criticise the other side. That's not just you never want to get into that. It might be that you will say in the procedural section, counsel have raised this point on this date outside their reasons for refusal, and therefore this technical information has been produced late. You might need to just deal with those sort of points for context, but rarely. And certainly it's not an opportunity to try and score points against each other about how you've conducted yourselves. It's normally that screams of sort of amateur approach to proofs of evidence. Normally you want to just keep focused, laser focused on what are the merits or problems with the appeal. Having it too long and boring, hopefully brevity is a point that, I say that noting I'm 50 minutes into this talk, but brevity is a key point in the production of proofs of evidence. You want to get to your case as quickly as possible, focus on those main issues, cut out the background as much as possible, and use your statement of common ground. It's your best friend. And inspectors, they just don't like really long, boring proofs. Sometimes they have to be long, as I've indicated, but you don't want to have it full of all the information they can find elsewhere. Another main mistake is failing to reach a conclusion on whether you conform with the development plan and or relevant policies. It is no problem. In fact, not only is it not a problem, it's encouraged that you make your concessions readily and candidly in your proof of evidence. It's where a witness has been reluctant to accept points in their proof of evidence. That's normally where they get dragged over the coals during cross-examination. If a witness is being fair and taking it on the chin, these are the things I've got to concede. And whether that's a local planning authority saying, I accept policies X and Y do support development in this scale in this location, or the developer similarly saying, I accept those conflict with these policies. Take it on the chin, and it removes opportunities for you to be criticised on the stand, because it is hugely effective for barristers when you have witnesses who are unwilling to make common sense concessions on the stand. It's normally where the credibility evaporates. So you want to make those concessions early and in your proof. And it is not uncommon for me to receive proofs of evidence where I see 60, 70 pages with all the background information I keep saying doesn't need to be there. And it doesn't actually deal with these points, which is the real points that the proof of evidence is written for, telling the inspector, this is what I agree with, what I disagree with. Here are the points you really need to decide and why I ask you to decide them in my favour. Style. Don't use contractions, don't, can't, won't. Subheadings are encouraged. Numbering, you want to have page numbers and paragraph numbers. You'd be surprised how often that isn't the case. And every time it's the case that you don't have that, inspectors always tell witnesses off. And again, you can see that. Format of the proofs, they tell us pages and paragraphs must be numbered. And appendices, bearing in mind you've got a list of core documents, more often than not, it's best to put separate documents in the core documents. Now, it might be, we had a question earlier from James asking about the modelling. If it's a very bespoke piece of work relevant to your proof, more often than not, it's best for an appendix. But if you're going to be referring to policies in the development plan, that's in the core documents. If you're going to be referring to a piece of guidance, that can go in the core documents. So you can limit how many appendices you really need. But the appendices, again, you want them to be usable and paginated. Not only does it save inquiry time and money, but it avoids annoying inspectors. It's such an easy way to aggravate inspectors and barristers that you don't have these things paginated. And again, it's an easy win to show you know what you're doing and you're taking it seriously. Changes in position. It's not uncommon that when you come to your proof of evidence, that your views on certain points have evolved, either because you've really thought and scrutinised it, or the barristers come on board and told you where they think you were wrong or right, or as you've just gone and had more attention on certain points, you realise things have changed. If you are changing your view, it's best to alert the inspector on the other side, notwithstanding this is what was said in the statement of case, having reflected on matters and having regard to X and Y, I take the view that it's in fact this. It's best to do that, because what you don't want to do is be seen to be changing your position left, right and centre and not have alerted people to it. And ultimately, it's oftentimes not a problem to change your view on points, particularly on subjective matters. If you're a landscape witness and you didn't do the LVIA, it's absolutely fair to say, I mostly agree with the LVIA, but I disagree with points X and Y, and just set that out. It smacks credibility, and it's much better to deal with these points. It comes back to the point of, being conciliatory, making concessions readily and candidly. Because if you make these points fairly, you're removing the ammunition for cross-examination. Barristers, we love it when you've got witnesses who are being difficult, because that's opportunity for us to attack you. When you're being fair and front-loading all these observations, oftentimes we've got nothing really to go at, which improves your prospects and makes your case much more credible. And then finally, executive summary. I encourage executive summaries. Now, we looked at earlier the PIN's guidance, which said that where proofs are longer than 1,500 words, summaries are to be submitted. So oftentimes you might have a summary which can, instead of an executive summary, the summary can be that. So you might not want to have it in your proof. But I still like executive summaries, and you want to sort of, this is an adage from another barrister called Jonathan Easton, King's Counsel, but he pitched this notion to me, and I really like it. Your executive summary, it's like you're pitching a movie. You want to just really hit the inspector. Here are the key points that I'm going to be making through this proof of evidence. And then I'm going to stop there, folks, and go back to questions. So Ellen asks, what's your view on referencing to third-party reports, evidence? How can we be effective in referring to these, provided they add to our case? Absolutely refer to third-party reports. I mean, irrespective of what side of the fence you're on, if you're for the local planning authority, you can say, well, the appellant's flood risk, if let's say flood risk is your case, the appellant's flood risk report said X and Y, and therefore I rely on that point. Equally, if you're for the appellant, you can refer to that point. Again, repeating information that's provided in other documents is, the PINs explicitly tell you, don't do that. Richard asks, when assessing the quantum of highway contributions, local applications are often viewed as setting an approximate precedent. When this is disagreed upon, how else might an inspector draw a conclusion? I think that's so fact-specific, to be honest, Richard. It's sometimes having other local decisions, they're not a precedent. They're never a precedent. It might be that they're useful and persuasive as to a level of contribution, but it's such a fact-specific question. It will just depend on the circumstances. And again, I'm not wishing to say you can never refer to other appeal decisions or local decisions, but my point is, more often than not, it's done in a imprecise and poor manner, and it oftentimes it's not an effective way of trying to persuade an inspector. And Emma asks, executive summary at the beginning or the end? I would say at the beginning. Capture the inspector right, if you're going to do one, right at the beginning when you do it. I can see a number of people are jumping off. So that conveniently, I think, brings me almost to the end of my talk, which is my final main mistake is not following the PIN's guidance. PINs have produced this very concise document setting out this is what you should and shouldn't be doing. Heed it. It's very short. There's literally no reason not to be doing it. And you can see a lot of the points they are relying upon are the same points I'm trying to pregnate of. Focus on the main issues. Be proportionate. All subtext, keep it short, keep it simple. Focus on the main points. Be concise, precise, relevant. Again, you can just tell inspectors read proofs that are far too long. Be prepared with clear structure. Focus on what is really necessary. All these points are just speaking to the point of being brevity, succinct. Focus on the actual case, not on all the background information. Where data is referred to, include the data and outline any relevant assessment methodology and assumptions. That speaks to the point. You can have your methodologies and as appendices, but include your key points from that. And then in terms of what they shouldn't do, said PINs have only put 2 points. There's really no reason not to follow them. And I think sometimes it's having that confidence to know, I don't need this. There's no reason I need to include this. The inspector knows all this. I don't need to include it. So folks, those are all my points. Hopefully some of you took something from that. This will be posted online. I'm sure most of that information, a lot of you knew, but hopefully next time you're writing a proof, some of these points might help you, and it gives you the confidence to think, I don't need to use this. This is irrelevant or redundant, and I need to focus more on my case. Anyway, folks, my name's been Killian Garvey. Thank you so much for all those who've contributed with questions and attended, and I hope you have a wonderful rest of the afternoon. Okay, bye.